A North Carolina Superior Court judge has issued a consent order in a decades-old North Carolina case about our state's public schools. At issue in the Leandro case is our state's constitutional requirement that every child must have the opportunity for a sound basic education. The question, of course, is how indeed do we go about that and who makes the decisions? Dr. Terry Stoops is Vice President for Research, also the Director of Education Studies here at the John Locke Foundation. He has been following this case literally for years and years and years, and Terry joins us now. Welcome back to the show.
Thank you.
So we know that it's decades old. Just give us kind of the Reader's Digest version of what this case is about. It seems that some people were saying that there are some North Carolina kids in some counties who really were being left behind.
Yeah, and that's absolutely right. In 1994, 5 school districts sued the state, alleging that students in their district were not receiving an equal opportunity, an equal education that they were entitled to under the North Carolina Constitution. Some school districts intervened, and together they went through the courts, and in 1997, the courts established this idea of a sound basic education, saying that the North Carolina Constitution guarantees North Carolina students an opportunity for a sound basic education. It was remanded to a trial court where there were various memoranda issued by Judge Howard Manning. It went back to the North Carolina Supreme Court, and in 2004 there was another ruling alleging that the state was not doing enough for at-risk kids. It would go to the Supreme Court again with a pre-kindergarten issue that would happen a few years after that. Since 2016, it has been under the watchful eye of Judge David Lee, with Judge Howard Manning retiring from the bench and Judge Lee being appointed the Superior Court judge that would oversee the implementation and compliance in the case. So that's where we are now, with Judge David Lee in charge of overseeing the constitutional issues related to the Leandro case.
The mere description here makes my hair hurt, and frankly, you got to feel for these kids they've grown out of the system at this point, the original kids that folks were concerned about. All these years, Terry, I mean, is that an indication that we really, frankly, just can't figure out what the issue is, we know what the problem is, but how to really solve it?
Yeah, I think that is a big part of it. And there have been various plans and remedies that have been proposed by the Department of Public Instruction, the State Board of Education, and lawmakers on both sides of the aisle about ways to address the issue with at-risk kids not performing at grade level in the major subjects, especially reading and math. And there have been various programs that have been proposed, and some skepticism from Judge Manning, not as much from Judge Lee, about what can be done to remedy these issues. And a large reason for that is that in 2016, when Judge Lee took over the case, the plaintiffs and the defendants decided to get together and to say, let's stop fighting, and let's get a consultant's report to tell us what we needed to do. So they finally decided to do that, and they contracted with a California-based consultant by the name of WestEd. It's a company that has gone in various states, North Carolina being their latest, to talk about what would be required to meet these constitutional requirements. And WestEd came into North Carolina. They did some limited research, and they pitched a report to North Carolina courts, and in 2019 they published that report. And so that really, since the publishing of that report, has formed the basis of the strategy by which Judge Lee and the plaintiffs and the defendants have gone forward to try to address this issue of low-income kids and at-risk kids not performing well.
Fast forward now to September 2020, and this is where we have this latest development, and it's really interesting because Judge Lee has now issued this consent order, and I know talking with you, I think we talked about it here on Carolina Journal Radio, you were concerned that the judge was going to issue an order that would require state legislators to spend a certain amount of additional money on public schools, which would set up a constitutional crisis because the courts it's not the branch of government that actually spends the money, that appropriates the money. That didn't happen in September. He issued an order, but he didn't issue a requirement. Tell us about it.
That's right. When the State Board of Education tried to get out of the lawsuit, and they're one of the defendants in the lawsuit, Judge Lee wrote an opinion where he basically talked about the fact that he would not be afraid to have a consent order that would require the state to spend money. Now, that was sort of a shot across the bow. He didn't do anything, but he indicated in that ruling that he would be open to such an idea, given how long that the constitutional requirement has not been met. So a lot of people believed at that point that this was Judge Lee signaling to the plaintiffs, the defendants, and everyone else that he was willing to sign a consent order requiring the General Assembly to spend more money. Now, the North Carolina Constitution is very clear about this, is that the North Carolina General Assembly is the entity that collects taxes and appropriates tax funds, and that the courts have limited ability to tell them how to spend this money. Judge Manning, when he was overseeing the case, never came close to even suggesting that he was going to tell the General Assembly how to spend money, but Judge Lee seemed to be willing to do so. And so many, including myself, suspected that this first order in the first year implementing the West Ed recommendations would have some sort of requirement that the General Assembly spend money. And in this case, a $427 million down payment on an $8 billion 8-year plan.
Wow.
That didn't happen, mostly because of the pandemic, really taking a bite out of North Carolina tax revenue. Going in to this year, going into 2020, North Carolina was in fantastic shape due to really great budget management, having billions of dollars at its disposal. And so it would have been very easy to say, for the judge to say, we have the money, go ahead and spend it, consistent with the Leandro requirement. But we know that now we are hundreds of millions of dollars short in what we expected to have in tax revenue, and I think Judge Lee was worried that such a requirement that the General Assembly spend money that really it doesn't have and is borrowing from the federal government would impair the state in a way, and certainly would lead many to doubt the ability of the courts to be able to address this issue and to hold the Leandro requirements at bay.
Terry, is it a fair characterization to say that with this order, the judge essentially said, yeah, I kind of like these ideas in this West Ed report, and so I want all of you involved in this to try harder, look at these ideas, try implementing these ideas. So rather than mandating you must spend X amount of money on this, just kind of saying go back to the table and keep working?
Well, this is one of my big complaints about the West Ed report, because I think the West Ed report falls short in many, many different ways. And Judge Lee basically signed off on it without having any hearings, without bringing the West Ed technocrats into North Carolina, putting them on the bench and asking them tough questions. As I said, Judge Manning, who oversaw the case for many years, would have done that. He had no patience for so-called education experts who proclaimed to have all the answers and tell the courts that they had all the answers, and then when their preferred programs were implemented, only to find that at-risk kids were no better off than they were before these programs were implemented. Instead, Judge Lee just said, if the plaintiffs and the defendants agree on this report, then I will too.
And Terry, you said something very interesting. You said, well, he didn't call them in and start asking questions. All right, so let's talk a little bit about some of those issues in the West Ed report. What questions would Judge Stoops have asked those folks?
Well, first, I would have asked, if we spend $8 billion, will you, West Ed, guarantee that North Carolina's at-risk students will improve? I would have had them say on the stand that they guarantee that full implementation of their plan would result in at-risk students being able to read and do math at grade level. I would have asked them about a lot of the inconsistencies and errors in their report. I pointed out in several pieces published by Carolina Journal and on the John Locke Foundation website that there were errors in the report. There were numbers that were confused. There were claims in the report, such as the fact that they argued that North Carolina hadn't increased education funding when their own table says that they had. So there were a lot of issues that I had with those parts of the report. And then there were recommendations that will absolutely do nothing to raise student achievement. One, which is included in the action plan this year, is to change the name of a test.
What does that have to do with anything?
Exactly, and this is part of the formal court-ordered recommendations for this year is to change the name of the kindergarten entry assessment. These are the types of things that were recommended by WestEd that the judge has uncritically accepted and that the plaintiffs and the defendants are championing that will have little effect on education in North Carolina, certainly for those that are the most vulnerable.
Terry, as I was reading your piece where you look at this consent order, and by the way, it's available at johnlocke.org, the headline, Leandro defendants begin implementing a misguided action plan for schools. As I was reading through it, you listed some of the different agencies and organizations that somehow are supposed to get involved in this, kind of adding more bureaucracy to this, and that's my take on it. Why more people? It seems like this just keeps going on and on and on. More people get involved, more ideas, but not more results.
That's right. And the courts are convinced that more agencies, nonprofits that need to get involved and have a role in the Leandro legislation. Under Judge Manning, although he was deeply involved in getting the whole pre-kindergarten issue out in front of the plaintiffs and the defendants, there wasn't a whole lot of other agencies that were involved, and our pre-kindergarten program is overseen by the Department of Health and Human Services, in addition to many of the other programs that Judge Lee believes need to be funded by the state in order to meet the constitutional requirements. So I list all these agencies, and I talk about the fact that the courts really haven't talked to these agencies, haven't talked to the UNC system, the community college system, really haven't brought them into the fold. So if the idea is that it is absolutely critical to get these other agencies and entities involved in the legislation, why aren't we talking to them? Why isn't anyone really talking to them and bringing them in to discuss what their role might be? This is an unfortunate trend in the entire Leandro legislation, is that Judge Lee really doesn't want to talk to especially our elected officials, who invited him to come to the legislature and discuss some of his feelings about the Leandro report. He refused to do so, and from what I can tell, he does not believe it to be necessary to engage these other entities in the work, even though his court order orders them to do so.
Terry, at the heart of this, of course, is North Carolina kids. And it's been going on so long, as we mentioned, a couple of decades. The kids who were the first group of children that people were really concerned about being left behind, they're adults now. But there are more kids who are in schools that aren't performing well for them. And we all, no matter our approach to it, of course, want kids to be able to get out and lead productive lives and be happy and fulfilled, support themselves, and have a basic understanding of information so that they have skills, that they can be productive citizens. So this lawsuit aside, what do we do about that for those kids who still aren't acquiring the necessary knowledge to get out and lead a happy life?
We need to meet them where they are and to realize that they are unique and have unique needs. If you think about this whole premise behind the lawsuit, it really exemplifies what it means to have a top-down approach to solving problems. having a court in Raleigh, having plaintiffs and defendants with a lot of the attorneys being in the triangle, not really thinking about what students need in their families, what students need as individuals. And that's why I'm a champion of school choice. That's why countless of peer-reviewed studies have showed that school choice programs are really beneficial for these at-risk and low-income children. Because it recognizes that they do have unique needs and that a one-size-fits-all system is not going to address them. So this is the entire premise behind Leandro is to try to get a court in Raleigh to do something for parts of the state that are far from Raleigh. And I think that's the absolute wrong approach. And unfortunately, the courts, the plaintiffs, the defendants have bought into that approach under the belief that if we just had more money, if we had one extra dollar, then we would be able to give these kids the education they deserve, when in reality, we've been feeding these schools dollars for years and they continue to fail.